So today class, I will just give you the overview of the changes, and from tomorrow I will start from the beginning of the BNSS again. So today idea is that just let me to you introduce that how these laws are different from the old laws, uh, why the need arises, what are the significant changes which we see in the new law which was not there in the old law. So when we see this name Bhartiya Nagarik Suraksha Sanhita, uh, sometimes it comes there's a big name, new law, major changes, etc. But see just the change in the old law and new law. What was there in the CRPC? It had 38 chapters. What is there in the BNSS? 38 chapters. So number wise it remains same. If you look at the CRPC, the total number of provisions, it had 528 sections. In fact, it has 528 sections. CRPC is still valid for old cases. Though section number wise it is 484, but the total number of sections 528. When we look at the new BNSS, total number of provisions are 533. So from the number of sections, we can say it's not enormously changed. There's a many things which are not being a large number of sections, new sections are there. It is not the case. So by and large, the number is in the same way. Only few sections are some deletions, some additions. In that way, it's work out. So in the new law, 533 provisions. Old CRPC referred to your IPC provisions. BNSS referred to Nyaya Sanhita, Bhartiya Nyaya Sanhita, BNSS, along with the others, IT Act, etc. can come. But what are the new things in the new law? Why we people claim and many people say that new law is a significant improvement upon old law? There are challenges also which we will deal with in details in subsequent classes. Uh, so the very significant improvement which we see in the new law is the use of scientific technology. So those you have done when you have done your CRPC, we know in section 61 onwards, etc., all those summon provision was there. So there is a four process to compel someone to appear: summon, warrant, proclamation, attachment. Similarly, production of a thing, we have search warrant, without search warrant, with search can be without search warrant, etc. Police power under 92 to send the notice and ask someone to appear for any document. Those kinds of powers under CRPC they used to. Now under the new law, almost every single process says, as the law suggests, it can be conducted by audio, video, electronic means. So earlier system where say police used to record a statement under 161 CRPC, now under the new law police can record a statement by audio video electronic means, by video conferencing, by the way we are interacting, same way they can record a statement possible under the law. Magistrate can record a statement or trial can be conducted by audio video electronic means. So the new law, the greatest contribution which we can say is the use of the technology. That they have the new law has provided with. One another significant thing which the new law has done along with the technology is it's a mandate for use of forensic science. So we see in the new law there is a mandatory provisions. Now it does not mean that the old law the police does not use forensic science. We know the cases, old age cases like Kathakali, Oghat, uh, a decade ago, Selvi versus State of Karnataka, Supreme Court laid down on the forensic evidences, narcoanalysis test, brain mapping test. So these forensic evidences were used from quite long time. In fact, Calcutta is a place where in India the first time the forensic evidence are used. We have the first lab in India. So all those credit is there, which the cap which we are wearing as far as Calcutta is concerned. But what the new law did is, new law mandate that in certain offences where punishment is more 7 years or 10 years more than that, the law mandate that the police has to use the forensic science in their investigation. So these are mandatory provisions, and accordingly, when these mandatory provisions comes, impliedly in all police station, police department, other department, there's a requirement of manpower, forensic scientists, experts, etc. We don't have that much manpower. There is a requirement of forensic lab. It will come to in every district. We have to establish forensic lab, because if we use that much forensic evidences in criminal trial, then we require that many labs. We require manpower. And accordingly, what the new law did is, while they mandate that where the punishment is more, we should use the forensic evidences. Parallelly, new law has given a 5 years margin to the government to cope up the challenges of manpower, etc. And so state governments by their date they can notify within 5 years when they are going to implement this provision. But again, it's very significant change. Second significant change which we see in the new law is, in many places in BNSS, law suggested some timeline. So timeline like say when the court has to frame the charge, the law says 60 days timeline within which the charge need to be framed. Once the charge is framed, the other side can submit application for discharge applications before framing the charge even. There is a timeline within which 60 days the discharge application has to file. Judgment, there are some timelines. So in that way, in many places in BNSS, we find there are some timelines are laid down. It will definitely help in disposal of cases quickly, fast, at least far better than what was there earlier. So we find this timeline thing which can definitely help in our investigations, trial, and the court delivery of judgment. Even the judgment, etc., some timelines are there. After a completion of the argument, within a specified time, court has to deliver judgment. We also many times argued that this new law BNSS are citizen friendly. FIR concept, we know, we look into much detail on the FIR. But the now law says FIR can be sent through audio, video, electronic means. Now, though it's not fully automatic registration of the FIR, still the person, once they send by electronic means, they have to go to police station, sign the formal paper for completion of the FIR procedures. But at least some progress we can say is being made. Citizen friendly, because now the law categorically says you can register a FIR in any police station, irrespective of the place where the offence is being committed. Very progressive wordings. So no jurisdictions issues in respect of registration of FIR. Many times people faces challenges where the law enforcement agencies or police, many occasions they refuse to register FIR on, or they sometimes just avoid on the ground of jurisdictions, that okay, it's not my jurisdictions, it's outside the jurisdictions, etc. The new law is categorically very clear that without any jurisdictions, etc., the FIR should be registered. So we can say it's a new development, progress in that regard. Under the CRPC, we don't had a mandatory provisions under which the law enforcement agencies must inform the victim about the progress of the cases, progress of the investigations. Now the criminal case is started, why we have a judicial system, why we have a court, why we have a prosecutor. This entire system is there because someone is victimized, and accordingly law is there to redress the persons who is being victimized, their grievances. So when they have to redress the grievances of the persons who is victimized, it is important that the law now the law says that police should inform the victims or the informant within 90 days about the progress of investigation. Very powerful provisions. We don't have similar provisions earlier. Is it enough? That's a different question we look into, but at least some progress are being made where victim is deemed to be considered as a stakeholder, and the victims being given should be given informations about the progress of the investigation. So I think it's a very good provisions. In some cases, law prescribe, BNSS prescribe mandatorily summary trial, sometimes accused examination by video conferencing. There are change in the systems of the functionaries. So we can see from the transitions from the CRPC to BNSS, there are some significant change. Some new thing has come up in the law. While there are many things which could have been brought in, which might not, which not being brought in. One of the thing which will create a challenge, which already started creating challenges, is the last section of the BNSS, 531. This is the last provision. And just have a look on the provisions very minutely what it says. It says that first part says clause 1, CRPC repealed. Clause 2, notwithstanding such repeal, so non-obstacle clause we have already incorporated there. And it says if immediately before the date on which the Sanhita come into force, there is any appeal, application, trial, inquiry, investigation pending. So if any process is pending as on 30th of June 2023, because the new law came into force on 1st of July, for all those cases, the procedural law will be applicable is CRPC and not BNSS. The last line, as if this Sanhita had not come into force. What's the difficulty? Why I said it will create difficulty? Remember, in our system, the cases take quite long time. So if you go to the magistrate court, you will find many cases which are pending from last 8 years, 10 years. Session court also in same way. Now, because of this law, the cases which were pending as on 30th of June, while we say CRPC is repealed, for a lawyer, for a judges, for other functionaries, everyone has to carry CRPC still for another 10, 12, 13, 15 years. So the lawyer has to go to the court along with both CRPC and BNSS. Judges has to keep both CRPC and BNSS. This will create difficulty. They could have make the provisions applicable in all cases retrospectively, subject to some safeguard that okay, if the accused thinks their rights are violated, then the accused can submit applications to the court for a specific process can be adopted under the CRPC or can be followed under the CRPC. That was possible. But completely applying prospectively, it create many challenges. Retrospectively, applications could have saved many those kinds of problems, which will envisage. In fact, in last few months, we have seen on many occasions, the higher judiciary says that look, some of the provisions of the BNSS will apply retrospectively. Some of the provision of the BNSS are more accused friendly. Some of the provision of the BNSS has laid down some safeguards. So if it's accused friendly, if it's laid down the safeguard, why don't the same provisions should be applicable to old cases and the safeguard shall be applicable equally to them also? For example, one of the most significant change in my view for the citizen of this country we will find in section 105 of BNSS. 105 of BNSS is basically in the chapter, if you can locate this section, it is in chapter where it says production, compelled to produce production of a thing. Earlier in the same chapter, all search and seizure, etc., being carried out. Now 105 BNSS says that when the police will go for doing a search and seizure, under 105 they have to mandatorily do this recording of the entire process by audio, video, electronic means. Excellent provisions, because on many occasions there's a allegations which raised against the police that there's a planting of evidences, or some other similar kinds of allegations that evidence are being manipulated, etc. Or the seizure witnesses are all pocket witness of the police, so police has just called two persons and then asked them to sign the seizure list, etc. All this happened. Now, once the new law says that the entire search and seizure processes, including preparation of seizure list, signing of the seizure list by the witnesses, handing over a copy of the seizure list to the owner, homeowner, etc., or the place where search is being carried out. Now, this process indirectly gives a safeguard to the citizens, where the chances of planting of evidences become minimal now. Excellent provisions. Now, why the benefit of this provision should not be extended also to the litigant whose case were started little earlier, where police is now going to do search. So, when they do the search under the old CRPC, they don't have such obligation. What is there under 105? But when they do the search under the new BNSS, they have to follow comply section 105 of the BNSS. So, there are some provisions which are very protective, is provide protection for the accused, etc. So those beneficial provisions could have been used had they implemented this law retrospectively. That possible. Substantive law cannot apply retrospectively. There cannot be any ex post facto law because of the constitutional protections. But the procedural law can. There is no such an hard and fast bar per se. What are the other changes we see in the Act? If we look at the BNSS, they make some changes in the definition, they make some changes in the structure. Now we all are sitting in Calcutta, all of you are from Calcutta. Now we all know in Calcutta we have a court called Metropolitan Magistrate Court, loosely we say Bankshal Court. It has its own legacy. Now under the BNSS, they completely eliminated the court of metropolitan magistrate. So there is no court such called metropolitan magistrate. So every court become judicial magistrate first class court. Similar way, if you visit the district court like Alipur or Barashat, among the session judges, you will find the another court called, apart from the additional session judge, you will find the assistant session judge court. Now the new law says there will not be any assistant session judge court. So there are, we'll find many some structural changes are there. Some bodies are completely omitted. There are some changes, for example, is a complete new concept which the new law has introduced, is called in absentia trial. So accused can be tried in absentia without their presence. Now we never thought of that we will have a criminal justice systems where accused can face trial without being present in the courtroom. That is one of the mandate for the fair trial principles. Now, the new law BNSS says the trial can be conducted in absentia. So, these are challenges we see how the court react, how the High Court and Supreme Court give their observations on these provisions. Because once we see it's being implemented, we look at the challenges which will come in with these cases. There is some changes they have made in respect of the functionaries. For example, one of the functionaries which created by the earlier CRPC, now BNSS, are the prosecuting agencies. Now, if you remember, you have done CRPC. In the CRPC, there is a section 25 which says about the assistant public prosecutor. After 25, section 25A was added much later, 2008 or so, where they mandate for directorate of public prosecution at the state level. So there it was mandate for there should be director, there should be deputy director normally in charge of a district. That was the formula there. Under the new law, they suggested that there will be district directorate of prosecution. Very interestingly, if you look at this chapter on the directorate of prosecutions in the new BNSS, earlier only the lawyers or prosecutors rather, they normally used to become prosecutors or public prosecutors, or their name will be there in the panel by which the people used to selected as public prosecutors. So basically, those prosecutors, they are also advocate. So having a particular practice period, they can become either assistant public prosecutor or public prosecutor, additional public prosecutor at high court, special public prosecutor. The new law, when they talk about this directorate of public prosecution or district directorate of prosecutions, they say that one of the qualifications could be a member of judiciary. So someone who is a judge of a session court level can be appointed as a director of prosecutions. Someone who is a judge of a judicial magistrate court level can be appointed as a district director of prosecutions. This give indication that might be the government has intention to depute from the judiciary some officers as director or deputy director or district director of prosecutions or assistant director of prosecution, sorry, assistant directors, there is a judicial magistrate who can become assistant director of prosecution. So, when we look at this new law, there are many structural changes are also there. Some definitions are also changed. Some new concept has been brought in, like in absentia trial, which was not there in the old law. In new law BNSS, it is section 356, which provide for in absentia trial. The proclaim offender declarations, the new law has mandate some timeline. They say like these kinds of offences, instead of these kinds of offences, they say the punishment is prescribed. Where punishment is more than 10 years, a person can be declared proclaim offender under section 84 in the new law. Under the old law CRPC under 82, it was only some specific offences under which a person can be declared as proclaim offender. So this way we find many changes. Let me just show you the first chapter. What are the changes which we can see? The new law has defined some term which was not there under the old law. So audio, video, electronic means. It was not defined earlier, but now the need arises because throughout the BNSS, law suggested for recording of the actions by the police by or other agencies by audio, video, electronic means. Even recording of the statement others can be conducted by audio, video, electronic means. New law permit it. Bail was never defined in the act. But now they have defined bail, bail bond, bond. There is some specific explanation has been added to the definition of investigation, though it was not needed. But this is I'll look into. Let me show you. See the definition of audio, video, electronic means. It says, see the word, shall include use of any communication device. Remember, the nature of communication device are changing. Earlier, we used to make communications through mobile phone only, laptop, then video conferencing, etc. Now, even if you have a CCTV camera in your home or some places, from there you can communicate. One can communicate from their smartwatch or other things. So the way we communicate in different senses, different times, different places, it change. And accordingly, need arises that the law must be very clearly laid down about it. So audio, video, electronic means, when we see this word, it says audio, video, electronic means shall include use of any communication device for the purpose of video conferencing, recording of process of identification, search and seizure, or evidence transmission of electronic communication, and for such purposes and by such other means as the state government may by rule provide. So very broadly, they defined this term audio, video, electronic means, and they refer to those kinds of a recording which can be conducted during identification, search and seizure, etc. Bail definition. Now, bail traditionally we understand, if you look at the all these CRPC books, etc., Kelkar, etc., bail is always considered as release of a person with some surety, execution of surety or bond. The same thing they have defined here. Bail means release of a person accused of or suspected of commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or bail bond. There's a difference on a bail. Now here they have added two words, bond, bail bond. When a person is released from the court has passed the order of release of the persons. Many of you visit court regularly or might be working with some lawyer. You'll find advocate clerks are there who become surety grantor. So bond and bail bond implies when one is when third person surety, one is when the self grantee. So the bail bond means an undertaking for release with surety. So when some advocate clerk or other person become grantor, we call it bail bond. When the person himself give guarantee, we call it bond. And that traditionally we also understand the same thing, but now the law specifically mention this word. Investigation, the definitions are by and large in same what was there in the old law. But they added a new explanation to the investigation definitions. An explanation says about the special law. So it says where any of the provision of a special act are inconsistent with the provision of the Sanhita, the provision of the special act shall prevail. Now we always know It is there in the common knowledge that special law always prevail over the general law. Some special provision is always prevail over the general provisions. So might be for clarity, now the definition of investigation include this explanation, which laid down the same principle that special law prevail over this Sanhita, Bnss. Okay, so that's basically the definitions part of the Bnss. That changes are there. There are other definitions also which we need to look into in the act, because we'll try to not only just changes but also what the law is there. We try to refresh our memory to look at all those provisions. So when we look at the chapter wise changes, I'll just to give you the overviews. I said in the functionaries, now functionaries are courts, public prosecutors, etc., etc. Among these also some changes are there. As we see, there is a provision for special executive magistrate, assistant session judge office is deleted, director of prosecution established. So these kinds of changes are there under the act. When we look at the chapter 3, which are on power of the court, we don't find any changes. Only some places, some fine amounts are being increased, etc. Chapter 4, which are on the power of the superior officers, we don't find any changes. And this chapter remains same. Arrest of the persons, we find some changes. So in the old law, for example, when we look at the arrest provisions, the main major power of the arrest was under section 41 of the CRPC. And subsequently, section 41A was capital A was added with a safeguards that in some cases that instead of police can arrest, they can send the notice under 41 capital A. Now they club together in section 35 in the new act. And earlier in the CRPC, there was no format in which the police should issue the notice. Now under the new law, Bnss says form number 1 is a form for notice under section 35. That means instead of arrest, police can send notice to the person. Those changes we find in this section. I just skip. This is the form of the notice which is there in section 35 clause 3. These kinds of a notice police can issued. For arrest, there are many changes. There is some power. For example, handcuffing reintroduced in some serious cases. Medical examination of the accused, etc. Some improvements are there where the law says that medical practitioner should submit the report at the earliest. Some mandatory, some safeguards are being provided. We know the old cases on the arrest part, Joginder Kumar, D.K. Basu. Chapter 6 on process to compel appearances, there are many changes, but by and large changes are in respect of use of electronic means, etc. So I'll just skip these provisions. Chapter 8 is there on the process to compel production of a thing. We find some changes. I said already 105, that's the last uh, 105 in BNSS that laid down the safeguards for doing the recording of audio, video, electronic means. All such and seizure under the new law need to be conducted by audio, video, electronic means. Uh, In chapter 7, we don't find any changes except some minor word changes. Chapter 9, security for keeping peace and good behavior, we don't find any major changes. Maintenance, again, we don't find any changes. Maintenance of public order and tranquility, which basically a preventive initiatives under the code CRPC it was. We don't find any major changes in this provision. Some minor changes are there. One section was 144A was there, which is deleted under 144A CRPC. It was added with some power to the district magistrate or executive magistrate. They can pass order if someone is doing drilling, etc. So that's prohibited now. Then preventive actions, chapters 12, we don't find much changes. Some enormous power which given to the police, and accordingly with this power only, many times people say that this new BNSS has creating police Raj. Very wide power is given under section 172 of the BNSS. Investigation chapter, there are many changes. We don't need to, we will look into much detail on the investigation chapter. The changes are there. So, the power of the police, then victim medical examinations, etc. So, there are many places, some changes are there in that. Chapter 14, condition requisite for initiation of the proceedings. We don't find any major changes. One very significant change is the new concept of deemed sanction. So, under section 218 is talk about the deemed sanction thing. So, uh, if you know, in the CRPC, there's an entire chapter on these sanctions provisions, where when the case is supposed to be started against the public servant, the law says you cannot take cognizance unless there is a sanction by the government, appropriate government. Now there the new concept, that in that sense this is very important, and the concept says that if the government did not refuse to grant sanction in 120 days, then it will be considered as deemed sanction. I think it's very powerful provisions, and rightly they have incorporated these deemed sanction provisions. Complaint to the magistrate and their proceedings of the complaint case say there are very significant changes are there, and we will discuss this in greater detail later on. Because some new thing has been incorporated which was not there earlier. Charge chapter, we don't find any major changes. Trial before court of sessions, no major changes except those audio, video, electronic means issues. Some timeline within which the charge need to be framed, the timeline within which the charge discharge application need to be made. So in that way, we can find some changes act. Trial by magistrate, similar kinds of changes of the timeline, etc. we can find there also, which we'll again look into in much greater detail. Trial of summon cases by the magistrate, not major changes, but again the timeline issue, audio video recording issues are there in that chapter also. Plea bargaining, again some minor changes are there, not very great changes. Attendance of the person detained or detained in the prison, chapter 24, no major, nothing has been changed, only some minor changes are there. For example, this is very good provisions, a new section has been added, 336, which empowered the public servant who retired or transferred, the persons who are appointed on his place as a successor in office, they can go to the court and give evidences. That's permissible under the law. General trial provisions, we find some changes like we introduced the concept of witness protections. Um, no adjournment, only two adjournment can be granted on personal ground, etc. Those kinds of things we can find. Previous 309, now 346, only two adjournments can be granted. 356 is about the in absentia trial, and we look into these provisions in detail. How the in absence trial can be conducted, will it be violative of our basic constitutional rights? Chapter 27 was about the accused persons of unsound of mind. Chapter 28 was about effective administration justice. We don't find any changes. Judgment, we don't find major changes. The section on the witness protection scheme has been added. Submission of this sentence for confirmations, etc. No major changes, but some timeline are being fixed. For example, the appeal for by the accused for forgiveness, etc. It laid on the timeline that within 6 months and 3 months, they should file application to the governor or president. Appeal chapter, no major changes. Reference and revision, no major changes. Transfer of criminal cases, no major changes. 34, execution, suspensions, remissions, and commutation of sentence, we don't find any changes. So far, mercy petitions are concerned when as I said, that when the accused file application for mercy petitions to the governor or president, they give in the timeline within which this application should be made. Bail, some changes are there. First time offenders, in respect of under trial prisoners, 479 makes some significant changes. Now the law makes very clear that for only for the direction for the grant of bail to persons apprehending arrest, that's the 438, and we find some changes are there which the kinds of protection which added in 438, now the new law has removed. Disposal of property, chapter 36, 37 is irregular proceeding, no major changes. Limitation in taking cognizance power, no major changes. Miscellaneous provisions. 530, trial and proceeding to be conducted by electronic mode. So now every single trial can be conducted by audio, video, electronic means, there's a law permit. Uh, Other changes, as I said, it's all you will find in many places sporadic. Some changes are there, but those changes are basically about the timeline, about the audio video electronic means used. So these are all for the beneficial provisions are there under the Act. Timeline, we find many places where the timeline is being mentioned. So, for example, in many places, if you see Bnss says some timelines are mentioned. 1940, 107, 107, 173, 173, 3. So, in that many places we find the changes, etc., in the law.